So good afternoon. My name's Gary Darnell. I'm the Wasco County Hearings Official. And for the record, it's about 12:07 p.m. on Tuesday, December 9th, 2025. This afternoon, we have one hearing on the docket. The hearing concerns a request by Michael de Ruyter for a conditional use permit to construct a wind energy generation facility on 29 properties located southwest of Maupin, off of Bakeoven Market Road and Highway 97. This is file number 921-25-000005-PLNG. Staff will identify the applicable approval criteria in the staff report. I would like to indicate, though, that we sort of have a hearing nested within the hearing, and that's under Ludo 3.740C, where the hearings official needs to approve the criteria regarding cultural, historic, and archaeological overlay district. So the hearing is generally conducted in accordance with procedures for contested cases, as described in ORS Chapter 183, OAR Chapter 137, and Section 2.090 of the Wasco County Land Use and Development Ordinance. Before we get into the testimony of the hearing, I'd like to describe the rules that we follow and the procedures that are attached to the hearing. The hearings can be characterized as being quasi-judicial and de novo. By quasi-judicial, that means there are certain due process rights that attach to the hearing, such as notice, the right to testify, the right to an impartial decision maker, and the right to a written decision based on findings and conclusions of law. De novo means that new evidence and argument is allowed as long as it's relevant to the approval criteria. The rules of evidence that we follow don't really match what you see in circuit court. Evidence that's admissible at the hearings are the type that commonly be relied upon by a reasonably prudent person conducting their serious affairs. I do exclude testimony that's not relevant material, or if it's unduly repetitious. It's important to note that you must raise your procedural and substantive issues at this stage of the hearings, or if appealed, before the Board of Commissioners. Failure to do so will prohibit you from raising those issues on appeal before the Oregon Land Use Board of Appeals. So you need to raise those issues with a sufficient degree of clarity so that other parties understand the issue and can respond if they choose to do so. The burden of proof, the ultimate burden of proof in these matters lies with the applicant to show by a preponderance of the evidence that all applicable approval criteria have been met. The record in this matter includes the staff report, the application and supplemental materials, any comments that have been received up to the hearing, and any written or oral testimony received at the hearing. If you're unsure whether you have a matter that might be in the record, make sure you present that formally to the hearings official. By a statute, you have the right to request that the record be held open an additional 7 days. You don't have to give a reason for the request, but it needs to be made before the hearing is closed. If the record is held open, and I suggest that that's probably a high likelihood, then we'll discuss how long it's held open and what are the rules for the open record procedure. You also have the right to request a continuance of the hearing. That matter is discretionary with the hearings official. So you need to show that merely holding the record open for a specific period of time is not adequate to address your concerns. The hearing is electronically recorded, so I ask those that wish to testify to follow a few procedures. If you are present and there's a forum with a microphone, please testify from that spot. And second, begin your testimony with name and your address for our record. In terms of the procedure, we'll begin with the staff report. That'll be followed by an opportunity for the applicant and representatives of the applicant to testify. Then there will be an opportunity for others who wish to testify in support. Following that, there'll be an opportunity for those who would rather not be identified as being in favor of or opposed to the application, but wish to raise a point or ask a question. And then there's an opportunity for those to testify in opposition. Following all that testimony, I'll turn to staff and see if staff has any final comments they wish to make. And then there'll be an opportunity for the applicant to present a summary testimony. Any person that has standing to this hearing can appeal my decision to the Wasco County Commissioners. Such an appeal must be made within 12 days of the date of the written decision is mailed. The appeal to the board is de novo, and that means you can raise new issues of law and fact, and new parties may participate. Finally, the code requires that the decision maker in these matters be impartial. In that regard, I'd like to indicate that I've had no ex parte contacts, nor do I have any actual potential conflicts of interest to declare. At this time, members of the audience may challenge my jurisdiction or the partiality of the hearings official. And you retain the right to challenge my impartiality at any stage of the proceedings. Hearing no challenges, I'd ask Mr. Bailey to present the staff report.
All right, before we begin, can everyone see my slideshow and hear me okay at home?
I'm good here.
All right, thank you. Good afternoon, everyone, and thank you, Mr. Darnell. Sean Bailey, for the record, Senior Planner, Wasco County Planning Division. Today, I will be presenting the findings and addressing the requirements for the request. The agenda today, I'll give an overview of the request and its background, the location and zone information, definitions for commercial power generating facilities and wind energy facility, relevant zone and overlay requirements, supplemental provisions and conditional use review criteria, fire safety standards, site plan and road standards, RS 215 dealing with transmission lines for public service, and additional information received since the packet was made available, and finally, staff recommendation and questions. And the presentation does include images and maps, so if you'd like me to slow down or back up, just let me know. The request is a conditional use permit for a wind energy generation facility with a maximum generating capacity of 149 megawatts. This facility will include a maximum of 33 wind turbines with a maximum height of 690 feet tall and a rotor diameter of 532 feet. There will be 8 miles of transmission line to tie into the BPA Maupin interconnection substation. There'll be 3 meteorological towers that are 344 feet in height, a collector substation, an operations and maintenance building of roughly 7,300 square feet, overhead and underground collector lines, a 75 megawatt battery energy storage facility system, and the project boundary is approximately 5,556 acres. In 2018, the applicants, that's two, all right. In 2018, the applicants applied for and received Planning Commission approval on a similar facility in the location of their current request. This previous facility had a smaller maximum generating capacity, more turbines that were smaller than the proposed currently, more than double the transmission line length for connection, and the overall project boundary was over 4,700 acres larger. The previous application took up a lot more land and produced less energy than the current. This application expired in 2021. In June of 2023, an application for a pre-application conference for the current request was submitted. This process allowed for agencies to review and comment on the updated request. This process was completed in November of that year, and the current application was accepted on January 28th, 2025. The application was deemed incomplete in February for undetermined legal parcel status of all properties involved, and as well as clarification questions regarding aggregate sites. In response to the legal parcel portion, applicants submitted a report in March clearing up a few undetermined properties and finding that one property involved was not legally created. And after review of this report, staff agreed with the findings. In May, the applicant submitted the necessary information regarding aggregate sites in regards to development. In April of this year, an application was received to validate the improperly created unit of land made up of 2 tax lots through RS 92-176. The application and preliminary plat were approved in June, and the process requires the final plat to be recorded to be complete, and the process is currently not complete but nearing completion. Because of this, a recommended condition is included stating that no development on the property in question will occur until the plat has been recorded. The application was deemed complete in September as a plat was progressing through the process, and an initial notice was issued out to gather comments for the request. A hearing notice was published on November 12th in the edition of the Columbia Gorge News, and the agency and surrounding area notice was issued out the following day. Here is one of the maps included with the application of the project area. It takes place between Maupin and Shaniko and is centered around Bake Oven Road and Highway 97. The property falls entirely within the exclusive farm use zone, and portions of the request or properties involved lie within the historic and archaeological overlay, the mineral and aggregate overlay, sensitive wildlife habitat overlay, sensitive bird site overlay, and the military airspace. Here is a list of all the properties involved with the request, which includes 8 miles of transmission line and over 5,500 acres of including the entire facility. 29 tax lots are involved. two definitions from the Ludo relevant to the request, and I'm going to read these, so sorry for a second. The commercial power generation facility, utilizing the facility for the purpose of generating power, a facility for the production of energy and its related supporting facilities that generates energy using means listed in ORS or OAR, such as solar power, wind power, fuel cells, hydroelectric power, thermal power, geothermal power, landfill gas, digester gas, waste, and dedicated energy crops available on a renewable basis or low emission, non-toxic biomass based on solid organic fuels from wood, forest, or field residues, but not including the production of biofuel as authorized through RS 215.213 in all zones which allow farm use, and 215.283 in the exclusive farm use zone, and is intended to provide energy for sale. Wind energy facility. A facility producing energy from wind and its related or supporting facilities. The use is listed in the underlying zone in section 3.215M for commercial power generating facility, which includes wind power generation facilities. This is a conditional use permit, quasi-judicial type 3 review. The request is subject to sections in chapter 3, which include the underlying zone and overlay requirements, as well as the following chapters: supplemental provisions, conditional use review, fire safety standards, standards for commercial energy, standards for commercial energy facilities, site plan review, road standards, and ORS 215.274, associated transmission lines necessary for public service. In the underlying zone, staff found the request complies with the property development standards where applicable, as some standards, including lighting standards and tower height and setbacks, are covered in chapters 4 and 19. Staff included recommended conditions for waterway setbacks, signage, lighting, and obtaining road approach permits to meet requirements where included. For agricultural protections, the applicant will have to work with landowners to execute and record farm forest management easements for the properties involved as required. The mediation ordinance is included as was required at the time of application. Since the application was submitted, this has been removed from the Ludo requirements, with the most recent update adopted in June to reflect the updated language at the state level. Applicants provided information to demonstrate that the project area is not on high-value farmland and contains 22% arable land to meet requirements and the additional standards of the exclusive farm use zone. To ensure requirements are met, staff included recommended conditions for soil erosion, weed control, and requiring coordination with landowners. Now onto the overlay zones. For the cultural, historic, and archaeological overlay, over OZ4, account number 12545 contains the Imperial Stock Ranch Headquarters Complex District, identified as the Hinton House, and is listed in the Wasco County Comprehension Plan. Only transmission lines are requested on the portion of this property and are located over a mile from the district. This overlay ultimately requires any request involving construction on a property in the zone to be quasi-judicial review, which we are doing today. A recommendation is included for the further coordination between the applicants and the State Historic Preservation Office, SHPO. And as for the mineral and aggregate overlay, OZ5, 5 tax accounts involved with the project contain mineral or aggregate sites, but the property does not fall within the overlay zones, or the portions of the project do not fall within the overlay zones. The request is also not sensitive to sound from nearby aggregate sites, which some of the information in this section is included. As for the sensitive wildlife habitat overlay, OZ8, and the sensitive bird site overlay, OZ12, these sections require notice and comment from ODFW. ODFW has been working with the applicants for over the process, starting with the original application, the pre-application conference, and the current application. Final comments from ODFW were received in September. Their full comments reviewed all wildlife information and surveys submitted with the request, which included a completed plot plan and sensitive resource plan, and their comments used in multiple sections of this staff report. ODFW stated that they approve with the timing and methods used by the applicants in their surveys and appreciated the seasonal restrictions they'll be using in regards to nesting. For the Military Airspace Overlay Zone, OZ15, applicants provided information and coordinated with the Department of Defense during the pre-application conference, and ultimately it was concluded that no potential impacts were expected. No updated comments were received for this application. Chapter 4 supplemental provisions essentially cover that energy facilities, including towers and transmission lines, are exempt from height restrictions, and that the request shall be a conditional use since the proposal includes structures over 200 feet in height. The next few slides will cover the conditional use portion of the project. But based on information provided by the applicants, staff finds the request is consistent with the comp plan and compatible with surrounding area. Applicants submitted a transportation plan with their application and have coordinated with ODOT and the Wasco County Public Works Department throughout the application process going back to the original. Recommended conditions are included that a road use agreement shall be reached with each agency, and they require road approach permits shall be attained where needed, and all permanent access roads shall be covered in gravel to minimize dust. Applicants submitted a fire protection and prevention plan and have executed a mutual aid agreement with the Bake Oven Shaniko Rural Fire Protection Association, as well as coordinated with the State Fire Marshal's Office. Emergency response plan was submitted with applicants and have coordinated with the Wasco County Sheriff's Department. Sheriff McGill commented in November there is no issues with law enforcement in regards to the project. For sewer requirements, portable toilets will be utilized during construction, and an on-site septic system with approval through North Central Public Health will be proposed for the O&M building. The application provides that an estimated 40 million gallons will be used of water during the construction process. A recommended condition is included requiring the proposed use to not exceed 5,000 gallons per day of commercial exemption for local wells from the Oregon Water Resource Department unless an appropriate approval is obtained through that office. For solid waste, a recommended condition of approval stating all solid waste will be disposed of at the landfill and a contract for services arranged through Waste Disposal Service and the recycling of proper disposal of clean construction materials will be used. Seven dwellings are listed within half a mile of the site boundary. A recommended condition requiring the request to comply with OAR 340-035-0035 for noise standards during construction are included, and a potential noise easement shall be achieved if the ambient background level is higher than 36 decibel threshold that this OAR requires. Further conditional use review covered wildlife, and as described earlier, the applicants provided a habitat mitigation plan and have been coordinated with ODFW through the process. Recommended conditions are included throughout the staff report in different sections, including later in the staff report in Chapter 19. Visual characteristics for the project were also considered, as the surrounding area is made up of rolling hills, ridges, canyons, ravines, and cliff faces. Recommendations were included for material reflectivity, earth tone colors, and sign restrictions, including advertisements, are included. Historical, natural, and cultural aspects were also included in the conditional use review. As briefly mentioned earlier, in OZ4, applicants submitted a cultural resource inventory for the project and coordinated with SHPO, as well as the Confederated Tribes of Warm Springs Reservation and the Umatilla Indian Reservation. To help meet requirements, an inadvertent discovery plan is included to be with the project. And as with all conditional use permits, non-compliance with any of the conditions of approval shall be grounds for the revocation of the permit. For fire safety standards, siding standards were included. All project buildings shall avoid slopes greater than 40% as required and was proposed. Defensible space will be provided. A plan provides a 300-foot radius of defensible space for each turbine, which includes 22 feet of gravel apron and 55 to 100 feet of concrete pad. All the structures proposed are composed of metal for fire safety reasons, and the O&M building will be built to building code standards as required by the construction standards section. Access standards are required. Transportation plans submitted with the application, new roads will be constructed or existing roads will be upgraded to standard. For on-site fire protection, applicant proposes to install sprinkler systems within the O&M building. A recommended condition is included requiring the applicant to coordinate with the state fire marshal to determine if the project is compliant with requirements for a commercial wind facility. Now for the energy facility standards. The request is a quasi-judicial level request through the Wasco County Planning and not an FSEC review because its maximum generating capacity of 149 megawatts is below the 150 megawatt threshold. Request was preceded by a pre-application conference and the required agencies were notified as requirements of this section. Recommended conditions are included for an Any increase in towers or in generating output by more than 25% of the requested maximum 149, an application for modification shall be required to be submitted by the applicant, or the CUP shall be voided. And any increase may lead to FSEC review if the threshold is crossed. The facility shall receive approval on the FFA form 7460.1 for aviation safety. Facility shall not create any material interference with communication systems. And the facility will follow OAR 340-035-0035 regarding noise during the construction process and ambient noise levels after, as discussed earlier. Comment was received from participating landowner Blaine Carver regarding the tower lights, stating, "I encourage the Planning Commission to approve the Imperial Wind conditional use permit, but require the use of aircraft detection lighting systems, ADLS." The applicant submitted a follow-up regarding this comment, stating, "Blaine and I discussed this topic in more detail on November 20th. We are committing to work with our landowners to mitigate any negative impacts from the project, and we will comply with all state law and FFA requirements regarding turbine lighting." The application provides information considering cultural protection, which was also discussed in OZ4 in the CUP criteria. As well, natural resource and wildlife protection was also discussed earlier. Additionally, recommended conditions for wildlife protection are included that state the facility shall avoid siting development in areas determined to contain active ground dens for burrowing owls or white-tailed jackrabbits. Buffer restrictions for raptor nests are included, and above-ground transmission line support structures shall follow the current and best practices for avian protection on power lines. And foundation areas for towers and transmission line support structures shall be designed to avoid the creation of artificial habitat or shelter for raptor prey. The application provides information considering fire protection and emergency response plans as discussed prior, as well as public safety reasons. The facility will have private land access, locked turbine towers, and fenced-off substations and O&M facilities. These will not be open to the public. As far as transportation and road usage, in addition to what was discussed prior, recommended conditions are included for temporary roads, road cuts, equipment staging areas, and field office sites shall be restored to the natural grade and revegetated immediately after construction. The applicant shall complete a road impact assessment geotechnical report for roads to be used by the project. Existing on-site roads shall be utilized to the fullest extent possible. As mentioned earlier, applicants provided plans for weed control as well as dust and erosion in the surrounding area. For underground collector systems, recommended conditions for these systems are included to ensure that a minimum depth of 3 feet shall be used, or shallower depths may be authorized where notification to the applicable landowner and safety measures are taken. Underground collection lines shall be utilized to the fullest extent possible. If the connection line must cross wetlands and the project cannot feasibly construct an underground system, then overhead lines shall be allowed to cross the wetland or water body. After approval and prior to development, the facility shall obtain all the necessary permits from the applicable local, state, and federal entities, and will obtain and properly display a site address. For the terminology, or excuse me, for the termination and decommissioning of the facility, a decommissioning plan shall be provided to the county and ODFW prior to development. This plan will include a plan to minimize the impacts to fish, wildlife, and the environment, a detailed cost estimate, and the permit holder will provide financial assurances equaling or exceeding the potential extra costs of decommissioning beyond the 50% estimated value of salvage value. Once the final plan and location is finalized and production begins, the latitude and longitude location for the facility shall coordinate and send all locations to the county GIS department for mapping purposes. And after 6 months of production, the facility will provide to planning with a report of non-proprietary power production. In addition to the underlying zone, the facility has the following setback requirements through the recommended conditions. Turbines shall be set back from non-project boundaries, the right-of-way of any dedicated road or any ground major utility facility line with a minimum of 1.5 times the height of the tower. The setback for minor facilities shall be 1.1 times the height of the tower. Unless sited within a public right-of-way, the new electrical transmission line shall not be constructed closer than 500 feet to an existing dwelling without prior written approval of that owner. For site plan review, as proposed, the facility meets the following requirements for off-street parking and off-street loading. A recommended condition of approval requiring a minimum of 2 bicycle parking spaces is required shall be used for the proposed O&M building. For road standards in Chapter 22, for all public roads, all new public roads or upgrades to existing public roads will adhere to standards in Section 22.030, and all new private roads or upgrades to existing private roads will adhere to the standards in Section 22040. Green Revised Statute 215274 covers associated transmission lines necessary for public service. Staff concurs with the information submitted by the applicants that the request complies due to the straightest routes with the shortest length and the least impacts, as it avoids sensitive habitats and impacts the higher value farmland. Alternative routes would be longer and much more expensive, and any alternative route required to avoid high value or arable land would impact surrounding farmland even more than it already would be as proposed. Since the packet was posted on December 1st, 2025, ODOT submitted updated comments regarding the facility, which included approaches where permits would be required and additional verification regarding culvert sizes and locations of proposed accesses. Comments were forwarded to the applicant, and a response was received from both parties in tandem on December 4th that they would coordinate and share information as they finalize their road use agreement. Additionally, since the packet was posted, the applicant submitted comment after an opportunity to review the recommended conditions. These comments provide that the revisions are primarily to clarify the specific actions Avangrid will need to take to comply with the conditions. We also request some formatting edits for terminology consistency and the addition of the references to plan to included with the CUP narrative. A request to delete 2 redundant conditions and revise 2 conditions due to lease agreements. They also requested to add the reference to the 75 megawatt battery energy storage system, BESS, to the project description. That concludes my presentation. The hearing officer has the following options. And due to the findings presented today and throughout the report, staff recommends that the hearing officer select option B, approve their request with the amended conditions and findings as described in the previous slides based on the updates submitted by the applicant. And that is it for me. Is there any questions?
First, let me compliment staff on a prodigious staff report. I found it very useful. I do have a couple of questions. One is, in your review of the proposed changes to the conditions of approval, does staff agree with those proposed changes?
Sure, read through. I agreed with them. I felt there was some redundant ones that could be just more defined in one condition versus separate. And yes, I agree with some consistent language changes. I didn't see anything that really altered the conditions. But yeah, my initial assessment that I agreed with their recommended updates.
Okay. Can you verify that the state fire marshal and the weed master have not commented on the applicable studies yet?
I have not received any final comments from them. I do know the applicant has been working with them, so they might have additional information when they speak. But I did not receive comment on this application. I don't believe I've had updated comments since the pre-application process.
Okay.
But they were noticed along with everyone else.
Okay. And finally, I have to disagree with the staff conclusion that attachment O has a inadvertent discovery plan. That last throwaway paragraph can't be categorized as a plan. It's really not a hard task, just basically identifying the procedures you would follow if you make a discovery of a historic or cultural or archaeological artifact that isn't already on the inventory. But that's not in attachment O that I can find. So, with that said, I would like to hear from the representative of the applicant.
I will be sharing slides that they have presented as well.
All right, good afternoon. Can everybody hear me online?
Yes.
Okay, fantastic. Good afternoon, everybody. For the record, my name is Paul Violante. I am a senior business developer with Avangrid. I believe an address was needed for the record as well. 3935 Southeast Mall Street, Portland, Oregon, 97202. Thank you so much for having me as the applicant. We can go to the next slide. Just a brief rundown. I'll try not to be overly redundant with Mr. Bailey's very thorough rundown of our project. We can go to the next slide here. I'll just give a little bit about Avangrid as a company. We are a leading U.S. energy company. We have more than 10 gigawatts of installed capacity across 23 states. We are headquartered right in Portland, Oregon. More specifically to the state, we have over 2.5 gigawatts of wind, solar, and gas facilities here in Oregon across Gillum, Wasco, Sherman, Crook, and Klamath counties. Just last year alone, we can say we have more than 400 full-time employees, and we contributed more than $25 million in taxes from our projects just last year. So we are proud to call the state of Oregon home and continue to invest in the state's economy and energy infrastructure. Next slide, please. So for this Imperial Wind project, which we're very excited about, we did want to just highlight some differences, which Sean did a great job at, and we just wanted to show this table to compare our 2018 conditional use permit with the 2025 proposed application. The construction was ultimately not proceeded on the original permit. Largely due to avian and military airspace concerns to the northernmost part of the original project footprint. So what we've done is what you'll see on the next slide. We shifted the project area kind of concentration of turbines a bit further to the south in this black outline and proposed turbine locations. The orange indicates the previous project footprint. And Sean, can we go to the previous slide one more time? So as you can see, we've really gotten efficient with the project layout. We've reduced the acreage almost by half. We've reduced the number of total turbines. Wind technology since 2018 has advanced considerably. We are looking to have some flexibility within this new permit just for the overall size of the turbines themselves, as well as the total generated capacity and the inclusion of our battery energy storage system, or BESS. Sean, we can go to the 2 slides from now. Yeah, we go one more. Just a list of studies that we have completed to date in 2024 and 2025. We have updated a list of biological and cultural studies. We have conducted a screening level acoustic modeling analysis, visual impact assessment, and we continue to coordinate with ODOT, the Wasco County Sheriff's Office, and County Public Works and Road Department to ensure future compliance on our construction and operations for the project. Next slide, please. Ongoing coordination efforts from here. We look forward to continuing coordinating with Wasco County on the CUP and pre-construction compliance requirements, as well as third-party agencies to maintain compliance on operation and mitigation plans. We will be working with, or continue working with the Bonneville Power Administration as we look forward to executing our interconnection agreement next year. At this rate, the target of early to mid 2027 start of construction with the earliest commercial operations date, or COD, would be mid to late 2028, at which point we will restore temporary disturbance following completion of construction. Next slide, please. This slide here, we just wanted to acknowledge that the applicant has received and reviewed the staff report dated December 1st. We, as the applicant, support the staff's proposed findings and conditions of approval with minor modifications to the condition language as have been discussed. The modifications from the applicant were submitted to the County Planning Department on December 5th, 2025. Next slide, please. And I think that is what we had. Just as our presentation, we look forward to addressing any comments and questions.
Well, as I mentioned to staff, I have some concern about the inadvertent discovery plan. Can your expert put together a paragraph that would basically sum up the requirements of that plan?
Yes, I have a response here, Mr. Daniel. As noted, condition 17 requires finalizing the IBP outlined in attachment O prior to development. So we will ensure the final plan is consistent with our other projects.
But I won't be seeing that, is that correct?
That would not, he would not be reviewing that, staff would be reviewing prior to construction.
I believe staff would be reviewing that prior to construction.
This goes to.
Yep.
Why isn't that available now?
Hello, for the record, my name is Elaine Albridge. I'm outside counsel with Davis Wright Tremaine on behalf of the applicant. My address is 560 Southwest 10th Avenue, Portland, 97201. Great question and happy to respond to it. This does go to what we were anticipating in case that we did need to provide any additional information in response to questions. We were going to ask to leave the record open in order to do that. So we could provide a more draft plan to be verified by the hearings officer to make sure that it meets the elements you are looking for. That was something we were going to discuss in our rebuttal portion of the hearing.
Okay, that's I can accept that. I don't think that's something hard that's going to cause you any problems. Just basically a list of the procedures that would be followed, assuming there's a inadvertent discovery during the construction period. I don't view it as a big deal. But I do need to see something.
Understood.
Okay. And then I have some concerns about sign off by the state fire marshal and the weed master, especially the weed master who's had before January to review the noxious weed control plan. I don't know if I have the power of issuing subpoenas, but if that's what it takes, I'd be willing to do that to get something from that individual.
Yes, thank you, Mr. Darnell. Regarding the state fire marshal, we have been in touch, and my understanding is that the fire marshal is reviewing our application and specifically the fire protection and prevention plan. We hope to have a response review any follow-up questions here in the coming weeks.
Okay.
Regarding the weed master, yes, I believe that is something that is still in progress that we're working on.
Have you been able to communicate with that individual?
I don't believe so. I would need to check with my permitting team to confirm that they've been in touch with them this year.
Well, I'm willing to light a fire under him if that's what it takes.
Understood. Thank you.
Okay, that concludes my questions at the moment.
Thank you.
Thank you. Are there others who wish to testify in support of the application? Are there those who wish to testify but would rather not be identified as being in favor of or opposed to the application?
I would. Sheila Dooley, 3300 Vensel Road, Mosier. And let's see, my concern, so I could turn on the video, I guess. Oh, it's not coming on. Anyway, my concern is the impact on raptors and migratory birds and also bats. I know they did in the staff report, they said that Sean said there'd be seasonal restrictions when birds are nesting, but I'm concerned about the rest of the time because I assume these birds aren't just there during nesting season. I know a lot of birds get killed by turbines. I wondered if there were other restrictions. And also the impact on bats. I know they get killed by the pressure or whatever. Anyway, I was just concerned if there was other restrictions.
I'll let
you.
the applicant address your concerns in their hearing summary. Are there others who wish to testify in opposition? Does staff have any final comments? Will there be a final
One
summary?
person is coming up for comment. 1 second.
Okay.
Jared Warnock, 86800 Bakeoven Road. I'm a landowner and resident out on Bakeoven. Just to touch on Blaine's comment, I'd like to also strongly encourage the committee to require this project to have the ADLS, the aircraft detection lighting system. I believe I read by 2028, I think these systems will be required for new projects. And so I think it's a very important thing to push for as far as light pollution in these rural communities.
Okay. I understand that you've had conversations with the applicant's representative. Is that true?
That was the commenter Blaine Carver that had been
Oh.
not this commenter.
Okay. Thank you. Are there others who wish to testify in opposition or have questions?
They're coming up.
Okay.
Excuse me, the light wasn't on. Vicky Ashley, 90530 Bakeoven Road, Maupin, Oregon, landowner. In favor of the project 100%, but would like to see the aircraft detection system as a requirement.
Thank you. Are there others who wish to testify? Hearing none, does staff have any final comments?
Staff doesn't have any more comments. I was asked if there's time for one rebuttal really quick from the
Okay.
applicants.
Oh, of course. The applicant has a
Then
right.
we approaching for a rebuttal comment.
Okay, test. Okay. This is Paul Violante with Avangrid representing the applicant in response to the aircraft detection lighting system, ADLS. As noted in the record, we've been in touch with Mr. Carver, and we greatly understand the concern around lighting impacts in this area. We are committed to working with our landowners to mitigate any of these impacts. We know that the Oregon state law, upcoming newly adopted state law, will require future wind projects that were approved applied with the FAA after 2028 will require ADLS. We anticipate that the state will require retroactive installation of ADLS, at which point we are prepared to comply with that and with the FAA, which again, also for the record, FAA has the complete authority to approve or deny the use of ADLS. If they decide that they do not want ADLS in a specific area, they can deny that request. So we continue to work with our landowners on this. We understand the concern. We would ask that the use of ADLS not be a condition of the Wasco County permit, understanding that it will be required in the future. But the timing risk around the FAA at this stage with our application would be a concern from us. So we're prepared to comply with state and FAA requirements and agree with the conditions that are set forth in the staff report around lighting for the turbines. Thank you.
Okay, thank you. Does that conclude the applicant's rebuttal summary?
This is Elaine Albridge. For the record, I was hoping to discuss the open record period and request if we could do a 7, 7, and 7 timeline, if that's acceptable to the hearings officer. Otherwise, we defer to your preferred schedule. But if we could at least get a week to provide the additional information in response to the questions around the IDP, and then also to address Ms. Dooley's questions about raptors and bats in particular. We have additional information on that and can provide some additional documentation with coordination with ODF and W in reviewing the surveys and the analysis that have been done for those species.
Yeah, those timelines are fine. What I'd like to do is set out a list of the conditions of approval that I'm looking at prior to the end of the first week to allow the applicant and other parties to review those conditions and comment. So the first 7 weeks will be an opportunity for the applicant to respond to the issues raised at the hearing. The second 7 days for other parties to review and comment on those responses. And the final week for the applicant for summary. So that would be December 16th, 23rd, and 30th. Is that
Great, thank you.
Does that work for staff as well?
That does.
Okay. So ruled. And if there's no more testimony before the hearing's official, I'll close the public hearing, again with the idea that the record's being held open until December 30th. Thank you for your participation. And prior to a week, I will get out a list of my proposed conditions of approval and look forward to receiving comment. Thank you all.
Just one more thing, just for clarification, are we continuing the record or closing the record?
No, the hearing is closed. The record is held open until the 30th.
All right, thank you.
According to the restrictions, in other words, the applicant's going to be responding to certain issues raised during the testimony. And then the next week will allow parties to respond to their comments into the record. And then they have a final week to provide summary and final rebuttal, but no new evidence during the last week. Is that clear?
Thank you.
Okay. So ruled, and thank you all for participating. Good afternoon.
Thank you for joining us today.